Should convicted politicians be barred for life from contesting elections? This debate has taken center stage in the Supreme Court, fueled by the arguments put forth by senior advocate and Amicus curiae Vijay Hansaria. As Amicus, Hansaria told the court that currently there are different benchmarks for government servants and politicians. Hansaria told the court that government employees convicted of offences involving moral turpitude face swift and stringent consequences. They are immediately dismissed from their positions, irrespective of their rank. This includes everyone from Class 1, 2, and 3 employees to those governed by the All India Services Act of 1951. Even Class 4 employees are not exempt. This strict action is taken to uphold the integrity and moral standards expected of public servants. In contrast, convicted politicians currently face a comparatively lenient punishment, a mere 6-year disqualification from participating in elections. To illustrate this imbalance, Hansaria draws attention to various statutory authorities, such as the Central Vigilance Commission and the NHRC, which explicitly prohibit individuals convicted of moral turpitude offences from holding significant positions. This inconsistency between the treatment of government employees and politicians raises valid questions about the fairness and consistency of the law. The Chief Justice of India D.Y. Chandrachud had indicated that the court would separate the challenge to the validity of Section 8 Part 3 of the Representation of the People Act from the efforts to speed up trials against politicians. Section 8 Part 3 currently enforces a 6-year disqualification on a person contesting elections after a criminal conviction. However, in December 2020, the central government expressed its reluctance for the Supreme Court to test the constitutional validity of Section 8 Part 3 of the RP Act. The centre was of the view that elected representatives, including MPs and MLAs, operate under distinct service conditions compared to government servants. While they are considered public servants, their service conditions are regulated differently, primarily through the oath they take to serve the citizens. The government's stance is that elected representatives already face qualifications under the RP Act and adhere to various Supreme Court directions and precedents, making it unjustifiable to challenge the constitutionality of Section 8 Part 3. The disqualification of convicted politicians in India is a matter of considerable importance. The contrasting treatment of government employees and elected representatives regarding convictions for moral turpitude offences raise questions about the fairness and consistency of the regulation. While the government argues that the current provisions are sufficient, the Supreme Court's deliberations will ultimately determine whether a more equitable and rigorous system should be put in place to uphold the integrity of India's political landscape.
From breaking news, detailed analysis, in-depth interviews and explainers, follow the Times of India. Subscribe to our YouTube channel. Don't forget to like our videos and hit the bell icon to stay updated with the latest.